Sa patuloy na imbestigasyon patungkol sa 150 million pesos na kinilumbat di umano ni Henry S. Oaminal patungkol sa multi-billion project na gagawin sana sa Ozamis Occidental ay patuloy pa rin isinisiwalat ni Deputy Speaker Dante Marcoleta ang katotohanan. Sa nasabing congressional hearing, halos maotal na nga si Oaminal at tila nagsisinungaling pa rin sa nasabing pagpupulong kung saan ang lahat ng ebidensya ni Deputy Speaker Dante Marcoleta ay patungkol kay Oaminal na kumulimbat di umano ng 150 million pesos kasabwat ang ilang miyembro ng DPWH at ang ilan pang mga local government unit sa Ozamis Occidental. Muling panoorin ang nasabing viral video kung saan nagkainitan si Deputy Speaker Dante Marcoleta at Henry S. Oaminal na kung saan siya ang nasasakdal sa 150 million corruption sa Ozamis.
Yeah, that's why we said,
Yes, I rule on that favor.
yeah, that is,
Laman,
Yeah,
building 1 and 2.
yes, Mr. Chair. That's why
Yeah.
I am
Mr. Chair,
part of my manifestation
would
that
like
it should be
to
stricken on the
inform
record.
chair
Yes.
that the project includes the third project. For example,
So,
in-
are you
in-
saying
in-
this is part of one contract?
Yes, it's part of one contract. The contract is this,
What?
19KJ0186.
Yes.
What is the construction of multipurpose building, open and close parenthesis, housing project, cluster,
1
with
and 2.
site development. So,
In Laman and in
The-
the other
the
barangay.
multipurpose are two types of building. These are condo types comprising of two buildings. And the cluster is in Malubang. So it is encompassed in one title only. This is the contract. That is
Okay,
why
then
is
I
why
stand to
it's
be
not
corrected.
correct.
If this is one contract, one government project, one allocation in the GAA, then this is part of the hearing.
Mr. Chair,
the only question, Mr. Chair, is the funding.
that is not my point, Mr. Chair, that I want to be stricken out of the record. What I want to be stricken out of the record was part of his presentation of the House bill that I filed, converting that particular area into an alienable property, Mr. Chair.
What
That
are
is
you
not
saying?
part-
The press conference, the
No, Mr. Chair. He was mentioning about the bill that I filed currently, and he was even insinuating if I made a disclosure.
it is premature to rule on that because we cannot rule on that yet because we haven't heard the facts of that particular case. This is just a one sentence allegation of one of the 8.
No.
Yeah,
It's not part of the 8, Mr. Chair.
it's not part of the 8.
Yeah, he was just mentioning about the House bill, which I am making. The House bill that I filed 8095, Mr. Chair. This is a separate House bill, no, which is not part of the agenda. This is not part of the resolution.
Mr. Chair,
He
the
was.
cluster housing, Mr. Chair, was built on a public land.
Yes.
And belatedly, he filed
Yes, I
He filed
remember.
a bill
I remember. Let me.
to remedy the situation,
Yes.
Mr. Chair.
Yes.
Uh,
Yeah, I know. I heard.
Because that particular public land is inalienable. It is not disposable. So he wanted to remedy this by filing a bill. The title of his bill is
Mr. Chair, objection.
seeking-
This is still my time.
seeking to
No.
reconvert.
That is not my intention,
I'm
Mr.
making
Chair.
a point of
He-
order.
No, on your point
He
of
is
order does
trying
not
to make-
German.
The residents of Ozamis that gave rise to this resolution is not only a single family, Mr. Chair. In fact, I will have to already inform the representative of the Office of the Court Administrator that a case was already filed with the Supreme Court directly, considering that this was made in extreme urgency, and considering further that the courts are in lockdown, their lawyers made it sure that it will reach the Supreme Court. Kasi masyadong mabagal kung pupunta pa sila Court of Appeals, because they're being faced now of they are facing what they called in their complaints inhumane demolition of their houses. So this is Lisel Torres et al. Versus Soliver C. Peras, presiding judge of RTC branches 15 and 35, GR number 250 170. I'd like to make a record also, Mr. Chair, that
Mr. Chair, parliamentary inquiry. Is the question addressed to the court administrator in a way influencing the Supreme Court to decide the case?
I think nobody can influence the Supreme Court because it's a separate and distinct branch of the government. It is just a simple question, and I hope the deputy court administrator will not answer if he feels it is exerting undue influence on him.
Thank you, Mr. Chair. I'm putting this on record because of an earlier statement that this representation did not have all the names of the residents who were complaining of the demolition. As a matter of fact, on January 11, 2020, 15 residents and their families already wrote to the committee secretary of the Committee on Ethics and Privileges, asking that their case be heard on issue of dignity, reputation, and conduct of a lawmaker, and I was given a copy of their complaint filed in the Committee of Ethics. So it is not unimaginary. It's not imaginary, Mr. Chair. This is a real case filed by residents in.
But let's stick to 1197 House Resolution.
Yes, Mr.
Yes.
Chair.
Yes.
I was about to say, but you have rolled it already, and I move that it should be stricken out of the records. That particular.
We do not take striking out very like left and right. We strike out. I think I've ruled, and that is enough. DS Oaminal.
Thank you.
Question to the Office of the Solicitor General. You said a while ago that the local government can use Republic Act 1052. Did you not say that?
Yes, Mr. Chair, Your Honor, we said
And under
that.
Section 3, if the local government resorts to Republic Act 10752, they will only expropriate rights of way, right?
Yes, Your Honor.
Only rights of way.
Yes, Your Honor.
Okay, but in this case, they expropriated several lots of land belonging to residents. That's not the right of way because they're going to construct two multipurpose buildings in those area. In that case, Mr. Representative of the OSG, was it right for them not to have resorted it through your office? Kasi dapat kayo.
Mr. Chair, Your Honor, our office only represents the national government.
I know. But considering that when they utilized and resorted to Republic Act 10752, they did not only expropriate right of way, but a location for purposes of building two housing projects. Do you think the measure or the action taken by the LGU is correct?
Mr. Chair, Your Honor, when we speak of the Right of Way Act, we speak not only of securing private lots, but also of implementing projects on those lots secured by the government.
That is a right of way.
Yes, Your Honor.
That is your opinion.
Yes, Your Honor.
Okay. And if they resorted to 10752, you already specified the three requirements. The amount equivalent to the sum of 100% of the value of land based on current value, zonal value of the BIR. That's number one. That's correct. The replacement cost of current value of the improvement and structures determined by the implementing agency, together with government financial institutions with adequate experience in property appraisal and independent property appraiser accredited by the BSP. And also the current market value of crops and trees within the property determined by government financial institution and independent appraiser. All this must have been immediately deposited in court in favor of the owner. Is it not?
Yes, Your Honor.
If these requirements are not deposited, for example, we have to ask whether or not the city government have deposited 100% of the value of the land based on current zonal value of the BIR. I'd like to ask the BIR, what is the present zonal value in Lamaan today? Is the BIR representative present?
Mr. Chair, it's a point of order. On matters which are now pending with the court and discussing on that very issue, would it be...
Mr. Chair, why am I being... I thought we
I'm
had an
just
agreement
asking
already that I
I'm
will
just
not
asking
be
the ruling of the
interrupted.
That's why
Every time that
I want to
speak,
figure out. That's why I'm also puzzled. I think let's just give him a little leeway. It's just the BIR who will answer.
No, because these are matters taken
Mr.
up
Chair,
by the
he has
court,
already
Mr. Chair.
recorded his
So if
continuing
it is-
objection. That was already enough. It was not necessary for him to interrupt this representation every time I raise a question. Otherwise, he will be misinterpreted as somebody who is trying to cover up this whole hearing.
Mr. Chair, I'm just doing what is supposed to be my duty as representative
You
of
are
the people.
not doing
And
what
it is my
not
right,
supposed to be. You have no right to interrupt.
Mr. Chair. No, I'm raising an issue which is now
Yes,
the
I
issue-
will rule on this DS Oaminal under rules section 1, paragraph 2, the filing or pendency of a case before any court, tribunal, or administrative body shall not stop or abate any inquiry conducted or carried out by this committee.
Yes, Mr. Chair, I know that provisions of the law, but the point that I raise is that he is raising matters which is within the jurisdiction of the court. It's the court who could answer, not the BIR. Because he is asking
Let the resource person answer.
whether the depiction has
Let
been
the
made.
resource person answer that if that is the case.
Okay, Mr. Chair.
Okay, thank you. Mr. Diaz Marcoleta, please.
Wala na lang gagawin, Mr. Chair, kung hindi interrupt ako, paano ako matatapos dito?
I think you're gonna ask the BIR, Diaz Marcoleta.
Before the BIR, Mr. Chair, may I go direct to the NHA representative? Anyway, I could take advantage of his presence. Mr. Representative from NHA, are you aware of Republic Act 7279?
Yes, Your Honor.
Are you also aware that in finding locations for resettlement or socialized housing, the proponent, in this case, the local government of Ozamis City, should have first coordinated with the NSA, its LURB, NAMRIA, and LMB in identifying lands for socialized housing prescribed under Section 8 of Republic Act 7279.
Yes, Your Honor.
Are you also aware that under Section 9 of this law, it provides that socialized housing are prioritized in particular order, and private-owned lands are last in the list of priorities? Section 9, Republic Act 7279.
Yes, Your Honor.
Yes.
Your Honor.
Under Section 10 of Republic Act 7279, there are several modes of acquiring lands for socialized housing and development. These are community mortgage, land assembly or consolidation, donation to the government, negotiated purchase, land swapping, land banking, joint agreement, and expropriation. There are 8 modalities. Do you confirm that?
Yes, Your Honor.
Okay. Under the same provision, it categorically provides that expropriation should be resorted only when the other modes of acquisition have been exhausted. Is that correct?
Correct, Your Honor.
And if these modalities have been exhausted, and there is only one way to do it, wala na mangyari. Expropriation na lang. But the final provision in this case, in this particular section, sabi niya, where expropriation is to be resorted to, parcels of land covered by small property owners shall be exempted for purposes of this law. Is it correct?
Your Honor, I cannot confirm that.
It's in Section 10. Basahin
not-
mo yung section 10. Sabi niya, provided finally, if expropriation is resorted to, parcels of land by small property owners shall be exempted for purposes of this act. This is section 10. I'm only reading it. Do you confirm this?
I will have to check, Your Honor.
Okay, check mo nga.
For a while,
Binabasa
Your
mo.
Honor. Yes.
And it's dapat alam mo ito. Ano naman ito?
Your Honor, regarding section that provision of RA 7279, yes, actually, those are all provisions of the
Yes.
of the law.
Okay.
Yes, sir.
OSG, please. In Section 19 of the Local Government Code, that's the right of eminent domain. But in the same provision, sir, it says that it also cites the Constitution and other pertinent laws on socialized housing and payment of just compensation. And such pertinent laws, which are also controlling in this case, are Republic Act 7279 on socialized housing and Republic Act 10752 on expropriation. Do you agree?
Mr. Chair, Your Honor, Section 19 refers to expropriation by the local government
Yes,
under
and
the
it
local
also
government
cites the
code.
Constitution
Yes, Your Honor.
and other pertinent laws. Kung
Yes, Your Honor.
pag-uusapan is just compensation and also socialized housing. And these controlling pertinent laws are Republic Act 7279 and RA 10752, right?
Your Honor, if the local government pursued expropriation not under 10752, then it will not apply.
No, sinasabi ko lang, pakinggan mo lang. Kasi sa Section 19, sinabi niya, kung i-exercise mo yung right of the eminent domain,
Hindi.
you will also refer
10
to the
minutes,
Constitution and other pertinent laws. So there are pertinent laws also that can be cited, like if you talk about socialized housing, this is the controlling special law 7279. Pag expropriation naman, the controlling special law is Republic Act 10752. That's the only question.
Yes, Your Honor.
Okay.
The 10752 is controlling on expropriation if that is the law applied by the government agency, like the local government unit. If the local government unit did not apply Republic Act 10752, then other laws will apply on expropriation, like Section 19, Rule 67.
You mean to say in socialized housing, the local government can ignore Republic Act 7279?
No, I did not say that, Your Honor. What I
Okay.
said, on expropriation,
Hindi, doon muna tayo sa socialized housing. In socialized housing, the controlling law is Republic Act 7279.
yes, Your Honor.
That is the question I asked from the NSA, and he confirmed that those provisions really exist in that law. Ngayon, ito namang sa expropriation, ang sinasabi natin, because they resorted to 10752, kaya sinasabi natin, they should have deposited all those amounts. That is why earlier I was trying to ask the BIR whether or not they deposited those requisites for them to be able to acquire the writ of possession. Okay, Mr. Representative from OCA, earlier you were asked by the distinguished Honorable Veloso on the writ of possession, the uncertainties, etc., etc. Does the writ of possession in itself also include the right to demolish without court orders?
Your Honor, with respect to this particular case,
Yes,
Your Honor,
yes.
there is mention about actually ejecting the occupants, but no writ of the demolition was issued, Your Honor.
There were no writ of demolitions.
None, Your Honor.
So, the writ of possession is not enough. They should at least apply for writ of demolitions or even evictions for them to enter the property, considering that there are residences.
Well, in this particular case, Your Honor, there was none that was applied.
Yes.
I think what ensued was negotiations perhaps involving the parties, because there were certain rulings already by the court thereafter the issuance of the writ of possession, Your Honor.
Earlier, I made a manifestation that there are at least 15 families who went to the Supreme Court questioning the writ of possession. And they were saying that there were no writs of demolition, and I was able to verify that personally from the undersecretary working at the time when I asked him to see to it from the ground what is happening there. And he confirmed to me there are really no writs of demolition. So that is why I was asking now, can they demolish the houses and residences absent the issuance of writ of demolitions?
Well, the demolitions, insofar as this case is concerned, is based on the voluntary.
This is not voluntary. They went to the Supreme Court asking the Supreme Court to help them. That's not voluntary. There are 15 families. In fact, they went to the Committee on Ethics filing this. So that's not voluntary. You saw the video clips earlier. They're not voluntary. They were crying for justice.
May I just put on record that there are sheriff's return regarding this particular
Demolitions, no sheriffs.
submission of, furnishing of the or service of the writs of possession to the concerned parties, Your
The
Honor.
only question I want you to determine,
Yes, Your Honor.
and you said it already, susiguruhin ko lang,
Yes,
yung writ of possession is not enough to demolish if there was no court demolition orders issued, right?
What I'm saying, Your Honor, is that when the writ of possession was issued, there was no writ of demolition
Yes.
that went with it, Your Honor.
There were no writs of demolition. Yan sinasabi ko sa iyo eh. Kaya tinatanong ko, was the writ of demolition, was the writ of possession enough kung walang writ of demolition?
Well, the writ of possession simply states, Your Honor, that the government, the LGU,
Yes.
is given possession of
Yes.
the property subject of the expropriation, Your
That
Honor.
is the only. But
In
if you will
compliance
demolish the houses absent the court orders of demolition, it cannot be done, right?
Your Honor, if let me just say, based on the
Do
obtaining,
not mince words here, Mr.
I am
Representative.
not, Your
from the
Honor,
OC.
because I'm just basing.
Ang sinasabi ko, kung walang court order of demolition, can you do it?
Well, to demolish, Your Honor.
Yes, to demolish the residences. 15 families came to the Supreme Court.
Your Honor, no specific writ of demolition does not necessarily follow that demolition should take place, Your Honor.
Okay, so they cannot do it without court orders, right?
But in the order, specific order involving this particular case, there was mention about ejectment, Your Honor. But
Walang ang ejectment, expropriation nga lang ito eh. There were no ejectment cases.
I'm just basing on the order, Your Honor.
Yes.
The wording of the order is to also eject, Your Honor.
Walang order na ganon. The writ of possession was granted to the city government, that's all.
Yes, Your Honor. But I'm basing it on the record, Your Honor. The order of Judge Pera states that and to eject, Your Honor. I'm just quoting the
Okay,
decision.
how can you
the order.
eject? How
Like I-
can you demolish the houses? Nilagay ba niya doon? That
wala,
included
Your
the writ of demolition? Wala, di ba?
No writ of demolition, as
Kaya
I
nga, so
mentioned,
if
Your
there
Honor.
is no writ of demolition, can they demolish? That's only the question.
Yeah, that's why we
Yes,
said,
yes, I rule on that favor.
yeah, that his,
Laman,
Yeah, that-
building 1 and 2.
yes, Mr. Chair, that's why
Yeah.
I am
Mr. Chair,
part of my
I
manifestation
would
that
like
it should be
to
stricken on the
inform the
record.
chair
Yes.
that the project includes the third project. For example,
So,
in-
are you
the
saying
budget-
this is part of one contract?
Yes, it's part of one contract. The contract is this,
What?
19KJ0186.
Yes.
What is the construction of multipurpose building, open and close parenthesis, housing project, cluster
1
with
and 2.
site development. So,
In Laman and in the other
the
barangay.
multipurpose are two types of building. These are condo types comprising of two buildings. And the cluster is in Maluubang. So it is encompassed in one title only. This is the contract. That is
Okay,
why
then
that is
I
why
stand to
it
be
is not
corrected.
correct.
If this is one contract, one government project, one allocation in the GAA, then this is part of the hearing.
Mr. Chair.
The only question, Mr. Chair, is the funding.
That is not my point, Mr. Chair, that I want to be stricken out of the record. What I want to be stricken out of the record was part of his presentation of the House bill that I filed, converting that particular area into an alienable property, Mr. Chair.
What
That
are
is
you
not
saying?
part-
The press conference, the
No, Mr. Chair. He was mentioning about the bill that I filed currently, and he was even insinuating if I made a disclosure.
it is premature to rule on that because we cannot rule on that yet because we haven't heard the facts of that particular case. This is just a one sentence allegation of one of the 8.
No.
Yeah,
It's not part of the 8, Mr. Chair.
it's not part of the 8.
Yeah, he was just mentioning about the House bill, which I am making. The House bill that I filed, 8095, Mr. Chair. This is a separate House bill, no, which is not part of the agenda. This is not part of the resolution.
Mr. Chair,
He was...
the cluster housing, Mr. Chair, was built on a public land.
Yes.
And belatedly, he filed
Yes, I remember.
filed a bill
I remember. Let me.
to remedy the situation,
Yes.
Mr. Chair.
Yes.
Um,
Yeah, I know. I heard.
Because that particular public land is inalienable. It is not disposable. So he wanted to remedy this by filing a bill.